I want to dig deeper now with Gabe Roth. He's the executive director of the nonpartisan Supreme Court reform group, Fix the Court. Gabe, thanks so much for sharing part of your Saturday morning with us. First, what did you think of the findings in this report? Was the investigation thorough enough?
I think it was as thorough as it could have possibly been, with a few exceptions. I want to give a caveat there, but the top line thing here is that we were never really going to find the leaker. Tons of resources were wasted, tons of time was wasted, and we end up with these unsurprising results. It's possible that the Supreme Court might have called in the FBI or some other investigatory body to help them. It's still unclear if they did. They said they fingerprinted, had a fingerprint that they did some forensic evidence on, and they said they had some security IT forensic work that was done by an outside organization. So that might have been the FBI. The Supreme Court itself doesn't really have an investigatory body, so the idea of doing it internal is a little weird. But my overall picture here is we were never going to find this person, and wasting countless resources on something that was never going to be answerable, going on this wild goose chase, wasn't a really good use of government resources.
Gabe, what makes you think we were never going to find the leaker?
I think it's the person who did this was very likely incredibly careful. It's very easy nowadays through Signal and other apps to get encrypted communications going. And this is something that I think the person will probably take to their grave. The other thing is, and one of those caveats is that the justices, maybe they were interviewed, but how closely were they interviewed? How deeply were they interviewed? I mean, I still think there are a lot of questions. The initial report that came out did not mention the justices. It just said employees were interviewed and there had to be a clarification. Given how many people had access to this document, and that's, I think, a valid question. How many people should have access to this document? It's probably fewer than the 82 people who had access to it. It's just the justices could have been investigated a little more thoroughly. But overall, I think the leakers, given the incredible nature of this, the unique nature of this, they were going to cover their tracks, and there are plenty of ways to do that. So it's very difficult to think that we'd ever figure out who he or she was.
You previously referred to some of the efforts by investigators as intrusions, things like examining Supreme Court employees' search history, asking them to turn over their call and text message logs, fingerprinting. Why are those intrusions?
I think that, you do sign away some of your rights when you come to the Supreme Court and are a judicial assistant or a clerk. Clerks work for 1 year apiece. There's about 40 of them, and then judicial assistants can work longer. They're more career employees. And you do sign away some confidentiality rights come with your job. But the idea that we're going to be searching Google history to maybe try to figure out who did the leak, I mean, come on, like, what is this? Like, that's not a serious investigatory tool. Confiscating phones, maybe if you have a Supreme Court issued phone, fine, take that. But your personal phones going into your personal, then you have the situation where some of the clerks, and this is reported by CNN's Joan Biskupic first, I think, were hiring themselves lawyers or talking about hiring lawyers when they were being questioned. It's a really sticky and messy situation, and this institution that you want to see is this paragon of impartiality and paragon of just following the law. The idea that we're having these interviews, and very likely there are no lawyers present for the people who are being interviewed. I don't know. It just sort of reeks as outside the basic legal structures that we have in this country.
Notably, Republican Congressman Mike Johnson of Louisiana says that he is going to reintroduce legislation to try to criminalize leaking information from the Supreme Court. Isn't it possible that a series of issues could arise from that kind of legislation?
Yeah, that's something that, and this is on the last page of the initial report, page 23, that I found a little bit curious. The court mentioned that it was potentially going to support legislation that would criminalize this sort of thing. But then earlier in the report, they cite 8 different federal laws that might have been violated by the leaker. I don't think we're in this place where we should be adding length and statutes to criminal law in this country. I think if the U.S. Attorney of D.C., if they found the leaker and the U.S. Attorney wanted to press charges, there are 8 different ways to do it. Having a 9th way of doing it, I think that doesn't make a lot of sense. And the fact that the Supreme Court would support a bill or suggest that they support a bill that only has Republican co-sponsors, again, is kind of ridiculous. It's supposed to be seen as this nonpartisan, apolitical institution, and it's saying, hey, this idea that Republicans had is a good one when it's frankly redundant. Again, just smacks me as tone deaf.
Gabe Roth, we got to leave the conversation there, but as always, we appreciate your perspective.
Thank you.